And we're live. Hello, everybody, and welcome to our live webinar, Understanding the Startup Visa Changes. We have a wonderful guest today. I'm going to be introducing her in a little bit. And we're very excited because we have 300 people registered, more than 300 people registered. And right now we have 100, almost 100 people already logged in. So it's going to be a great webinar. I'm going to wait for around 3 minutes so we can get started and wait for some people to jump in. And before we do, feel free to let us know where you are located. Where are you joining us from? I would love to know. And I'm checking now the list. I see a lot of familiar faces and names. Let's see, we got people from, oh my God, Brampton, Vancouver, Toronto, Calgary, Orangeville, British Columbia, Surrey, British Columbia, Montreal, Brampton, nice, Vancouver. Welcome, everybody. Thank you for being here. It's a very nice topic, a very nice guest. So we're very excited. Hi, Mohammed from California. That's nice. Okay, great. Thank you, everybody, for being here. A little bit of the basics. Some of you have already attended, so you know how it goes, but I'll recap for those who are joining us for the first time. So basically, we're going to be talking about the startup visa changes. I'm going to introduce our guest, then we're going to have a few questions that we've prepared. And then after that, we're going to have a Q&A session. You have the chat tab, the one where you are sharing your location. You have that chat tab to have any comments that you want to add during the event. We will be taking the Q&A from the questions on the right lower side where it says questions. If you could add those there, that would be great. We did receive from everybody who registered the questions that you suggested, so we try to add those in as well in the questions that I'm going to be asking Zeynab. Okay. And then for everybody who's here, we have the recording will be sent out as soon as the event is over. And that would be for attendees and also people who registered. Okay. Okay. Great. I think we can get started now. So hello again, everyone, and thank you for joining us today for our webinar, Understanding the Changes to the Startup Visa Program. My name is Marianella Manzur. For those who don't know me, I'm the Global Director of Sales and Marketing here at Joorney, and I'll be your host for today's session. It's truly an honor to welcome each and every one of you. I can see many familiar names, not faces, but names. And for those who don't yet know Joorney, let me quickly give you an overview. We are a global company with offices in US, Canada, and Australia. We have a team of more than 180 experts, and we specialize doing business plans for immigration purposes. We do more than 6,000 business plans a year across 160 different industries. And our Canadian offices specializes in doing business plans for different immigration programs. And today's focus is going to be the startup visa. So during this webinar, as you know, we'll be discussing the recent changes announced and to be announced by IRCC. The updates have been a topic of a lot of discussion, and we're excited to provide some insights and answer your questions also at the end of our session. As most of you know, Joorney focuses on the business plan side of things. So we do not provide legal advice. I wanted to share that small disclaimer. Of course, many of you are fantastic partners and you take care of the legal aspects of the application, of course. And today we have an expert, an incredible expert joining us to explain all the changes to the Startup Visa program. So let's give a warm welcome to Zeynab Ziaie. And I'm going to give a, hi Zeynab, how are you doing?
Good.
Let me put you on stage.
Thank
How's
you.
it going?
I'm good. Thank you for the invitation, for this opportunity to talk about so many changes that we've seen over the last year and the Startup Visa program. I'm happy to answer the questions.
Wonderful, Zeynab. Thank you for being here. I just wanted to have a brief introduction about Zeynab. So Zeynab, she's an immigration lawyer, and she has been assisting businesses and individuals with their immigration needs for over a decade, with a practice that merges business and immigration law. She advises clients on a wide range of immigration issues and provides strategic advice for short-term visa planning and long-term immigration purposes. Zeynab is also very involved in Toronto's tech community and regularly represents Canadian startups in bringing foreign talent to Canada, as well as assisting startup companies to come to Canada, either through the Startup Visa program or other programs as well. So once again, a very warm welcome to Zeynab and all of you joining us today. We truly appreciate the fact that you're here, and we look forward to an engaging and informative session. Great. So we're ready, Zeynab?
Perfect. Thank you once again. I have prepared some initial information with regards to the startup program. In terms of my involvement with this program, I've been working on applications from 2016, 17, and have really seen the evolution. And a lot of the changes that we're seeing this year are really a response to changes in the volume of applications and the delays that were causing all kinds of problems for applicants. So we've been asking for clarification from IRCC. We just didn't expect that the clarifications would come in the ways that they have. But I still think it's great that we do have more information and that we can use that to better assist applicants with preparing their applications and also trying to reduce the risks involved, making sure that applications have the highest chance of success.
Excellent, Zeynab. Let me share your presentation.
Perfect. Thank you. That's
great. Yeah. I also wanted to thank you, Zeynab, because we've seen that there's a lot of information about the changes, whether if they were announced in a specific event or if it was from directly from our minister. So I wanted to bring you here and to share the information with everybody and try to centralize, summarize, and focus on what those changes are and go into them. So let me just share your presentation and you can take it away.
Sure. Thank you. I'm going to touch on the biggest sort of guidelines that we've actually received, which are the May 2023 updated work permit instructions. I'm sort of basing this conversation on most of the participants here will have an understanding of what the startup visa program is. So we're talking about the changes only. And these changes were very concrete. And I know that we have the June 2023 instruction announcement, and I'll go through that as well. But the work permit changes, I think, the most telling in terms of being able to guide us as to what IRCC is thinking when they look at these applications. So starting as of May 18th, if applicants are submitting a new work permit application, they have to meet the new requirements. And this is a summary of them. Work permit applications can only be submitted after PR applications have already been submitted. This was not a requirement before, but it is 100% a requirement now. They want to have proof either that you have received a file number or acknowledgement of receipt for your application, or that you have the proof that you submitted it. So the screenshots, for example, from your portal that you've submitted the application, and where there's more than one essential team member, that all the essential team members have submitted their PR application. So there's 2, potentially 3 essentials identified on that commitment certificate. All of them will have to submit their files before the work permit can be submitted. And another sort of additional requirement is that the commitment certificate has to be valid at the time the work permit application is being submitted. I'm not sure why this was added as a requirement, because when you submit your PR application, your commitment certificate has to be valid. We know that it has 6 months validity. And I think that should be sufficient to demonstrate that you had the commitment required. But unfortunately, IRCC sees this differently. So if it is the case that it might take some time from the moment that your client is receiving the commitment certificate to applying for permanent residency and then making sure they have all the documents for their work permit. If it's beyond the 6 months and that commitment certificate has essentially expired, they'll have to go back to the designated entity and obtain a new commitment certificate. Otherwise, a work permit will be refused. The other clarifying point is with respect to the offer of employment. In late 2022, we dealt with literally dozens of applications, potentially more than 100 applications that were refused for using the LMI exemption code that IRCC had told people to use. So there was a lot of confusion and refusals. We were successful in representing a lot of clients and getting their startup work permit applications reopened because IRCC had conflicting information about what code to use. But as of December 2022, the code for startup visa applications is A77. You have to use this code. You have to also provide explanations when you submit your offer of employment of why it is that your client meets this exemption. So it would include submitting copies of the commitment certificate and explanation letters. But there's no leniency on this one anymore. There used to be if you use one of the two codes, but now there's a very clear requirement of which code has to be used. I'll also just put in a little sort of asterisk here. You have to create the offer of employment through the employer portal. The employer portal was not allowing the use of A77 for months, I think from something around May until very recently, and it was fixed back in end of July, early August. So if you're submitting applications now, you can do it. If you ever face another situation like that where you're not able to use the portal, it is possible to submit a paper offer of employment form, but you have to follow the instructions for that. The other really big changes that have come out through the announcement in May is, we're getting an understanding of what IRCC thinks about startup visa applicants. And the net worth requirement that they've essentially added into work permit applications is a big indicator of that. The startup visa was created as different from the existing business programs that Canada has, and the business programs, all of them had net worth requirements. And the unique thing about the startup visa was that it didn't have that. It just had, you have to demonstrate your living expenses. And for the work permit, it had to be for a whole year and not just 6 months. The addition of the net worth requirement, I think, goes to the concerns that there might be that, this is being used as a pathway for immigration, and people don't actually have the funds to make those projects that they anticipate into a reality. I think it kind of makes sense, but it also is not very understanding of the way that startup visas work. And I think that was what was very unique about the startup visa program. It was focused on high growth companies. A lot of times, if we look at those, the ones that are very successful, they're not self-financing their operations and their growth. They have unique ideas, they have skills and so on, and they may be bootstrapped for a little bit, but then oftentimes the idea is that they're going to raise funds. So this has been introduced as a requirement, but I anticipate that it's going to create issues because what is the minimum required? They're probably going off of people's business plans and their projections, but it might also bring things into sort of perspective of if people were potentially submitting applications with wildly exaggerated numbers that required high levels of investment, they need to go back and take a look at that and make them more realistic or have sufficient proof of how those operations are going to be funded. So I think that's one of the complications that we're going to see here.
Zeynab, and I'd like to ask a question here specifically about the reason. I mean, what do you think is the rationale for asking for a PR application and then the work permit?
There might be a number of different things. I think a big part of this is trying to limit the number of applications and making sure people are serious about their applications. I personally haven't seen this, but I have heard of situations where applicants are obtaining a letter of support just to get the work permit. I don't think it's a big problem, honestly. I think it's probably a small number of people, because just getting a commitment certificate is a huge process that you have to go through. But I think it's all of these restrictions are showing us that IRCC wants people to demonstrate more clearly upfront their commitment to their startup and their ability to actually implement them. And part of making sure that you submit your PR application first, I think, is just another aspect of that, making sure that, you know, you have the language, you have the other requirements. Yeah.
Exactly, that they're serious about going through PR after, and not necessarily like an optional plan, right?
That's right. That's
Um,
right.
yeah.
Exactly. I mean, one of the other things that they made clear is that when you submit the work permit, you now have to include, for example, copies of your language exam, and the office are going to look to that. Versus before, that wasn't clearly a requirement for the work permit.
Yeah.
And similarly, in the last item I have on this list is proof of education and work experience to demonstrate that you can actually do the work that you're saying you want to do in Canada. Now, this is something I've been advising people to include in their applications even before these guidelines came along, but they're extremely important. Again, they're demonstrating to an officer, to the ultimate decision maker, that this is a genuine application, that this person has the skills, has the knowledge and the ability, and with the funds, they have the necessary resources to actually take this plan. It's not an abstract plan. It's not something that's not going to actually happen, and they're going to turn it into reality. So all of these are just guidelines for applicants to be able to, I think, better understand the process, and for representatives to be able to guide their clients. Actually, from that perspective, I think that these are actually very helpful. One thing I will just touch upon, which is point 5 here, is that it's always been the case that you have to explain when you apply for the work permit why you want to come to Canada and what the urgent basis is in terms of what you're doing. They just made that more clear, and that's because there were a number of cases in court recently on this point. So they've kind of made that very clear in the guidelines that if you are applying, you have to say what it is that the person is going to do in Canada and why they need to be in Canada to do it. Yeah.
Zeynab, and can you mention an example of what that urgency would be for a couple of startup visa applicants?
It really does depend on the context, what exactly they're doing, where they're coming from. I've been called on to advise a lot of Iranian applicants. One of the big challenges that they face is, even if they launch startups and so on, they can't take care of banking until they're here on the ground in Canada, because that's a huge concern. So that can be one thing. There are certain activities that you might actually need to meet with partners, with vendors, with potential customers, and you actually need to be physically present. Having Zoom meetings or online meetings might not be sufficient. Depending on the type of work that's being done, some startups, for example, specifically in tech, will require their presence in Canada because of the data that has to remain here and can't be processed outside of Canada. So we have different kinds of ways of thinking about this. And it really goes back to, again, what exactly the business is doing and what the needs of the business are. A lot of time, the sales component, right? Like being here, participating in in-person meetings, participating in conferences or exhibits and so on are key to being able to expand. And those are really helpful examples, I think.
Definitely. No, and these seem reasonable. I mean, if we think back regarding the focus and the purpose of the startup visa itself, basically immigration is trying to make sure that it is used for the purpose that it started, right? The only one that maybe it's a little bit limiting would be the net worth, just because of the nature of startups themselves. But maybe that could also be handled by things such as capital commitment by other entities and things like that. Sorry, I got my room with a sensor. Now I got my life back. Great, Zeynab. Let's go
I
ahead.
completely agree with you on that one. The other thing, which I think is the challenging part, is there's now a mention in there that you have to demonstrate the significant economic benefit that the startup is going to have for Canada, right? And I think this is where it starts to get very challenging. The two excerpts that you see on the slide are specifically from IRCC as of August. They've updated some of their instructions, and the list on the left, which is documents we recommend you include, I think it's extremely helpful. These are things that I've been advising people to include in their applications. Business plan, this is where Joorney comes in, and some of those other specific documents that are listed there. And this is extremely helpful because IRCC's basic checklist never included these, right? All you had to include, whether you were applying for the work permit or for permanent residency, was the bare minimums. And that left people under the incorrect impression that that's what you needed. And if we go back to the way in which the startup visa was initially announced, it was this idea that the government and visa officers are not experts in this area. We are delegating this to the experts who are the designated entities, whether incubators, angel investors, and VCs, and they should be the ones who are assessing the ability of this, the viability of it, the ability of the founders, and so on. So really, I think, people were under the impression, and initial application reviews were really like this. If you had a commitment certificate letter of support, that took care of all of this analysis. But as the number of applications has increased, as they're looking at trying to sort through over 15,000 applications that they currently have, they're now introducing these additional requirements. And I think it's troubling to think about a startup visa within the context of this specific significant benefit proof that you have to provide, because you should have essentially gone through something very similar to this as part of getting your letter of support and commitment certificate. So it's really duplicating work, and it requires a resetting of client expectations. You have to go back to clients and say, we did this once, but we might have to do this again throughout the process. You certainly have to do it for the work permit. And I think down the line, we're going to see more instructions on the permanent resident side, that officers are looking at these things specifically when they're making their final decisions. And it does make things much more challenging and difficult. And it gives officers, I think it also put officers in a difficult situation. They're not trained as business analysts. They're not trained to understand the changing dynamics, how startups might pivot and things like that. They might have some experience with more traditional businesses, but they certainly wouldn't understand this without, significant training, and they don't have the time for that. So this is going to result in potentially trouble for some startup visa work permit applications in the near future. And so my advice would be, if you're putting together new applications, go back to the basics on these and make sure you're providing documents and evidence and explanations to all of these. It will require a lot more work compared to what we used to do, for sure. Yeah.
Exactly. Yes, I totally agree, Zeynab. It's a process that people felt that with the letter of support it had ended, but it's definitely the case that it's only starting, right? And it's only a first very small part of what you're going to face later. And another thing we're seeing on the business plan side of things that is not necessarily on the startup visa is the significant benefit requirement or expectation from the officers, not only for the startup visa, but also for, of course, significant benefit applications, but also ICTs. They are asking, where is the significant benefit? We also want to see that. So we see that throughout immigration. They are wanting this to be highlighted. And even though for the letter of support, because of the requirements of the startup visa, that should have been checked, it's popping up again to make sure that it's written, it's formal, and it's being like confirmed formally again, right?
Yeah. It seems a little redundant. again, because there's so much work that goes into it, but I completely agree with your characterization that the commitment certificate and submitting your PR application is really the first step. That's when all the rest of the work starts, between when you submit and the 2-3 years or potentially more that it's going to take for them to open your application and come back. And we'll touch on that in a few seconds too. Okay. So these are the concrete, details that we've actually received from IRCC. And then we had some very flashy announcements that came out at the Collision Conference. The minister was on the center stage there, and I think that speaks to the importance of this program. So people ask me, do you think this program is going to be stopped? Is it going to be discontinued? I don't think it will be. I think it will be changed. That we will see more changes, I think, in the coming year in terms of being able to manage this and resolve some of the problems that exist in it. But given how center stage literally the announcement was and how important this is as part of Canada's tech talent strategy, I don't think the program is going to go away. So all of these discussions that we're having, it's to sort of get us all up to speed on what the latest changes are and how we can better position applicants. So the big announcements were threefold. One was this idea that there's more quota that's been allocated to applications. And as of 2023, that's already at 3,500. I mean, we knew that from before, and it's going to increase to, and I have to say,
5,000?
Yeah, 5,000 next year and 6,000 the year after.
Yeah.
And that's the total number of business applicants on the federal side. So it does include self-employed, but self-employed is such a small number that we're likely to see this being the quota. The challenge is, even though, for example, last year the quota was 1,000, they only got through processing of 550 applications. It was a significant increase on prior years, but it still wasn't anywhere near that number. I know that they're processing more applications because we are seeing a lot more update requests, and applicants past that stage of their application being open for review. I'm not sure if they're going to even reach the 3,500 this year. So that's something that we're going to pay attention to and watch out for.
Yeah. So part of it is the hope of what immigration wants to happen, and then the other part is what they can actually do, right? I believe, Zeynab, you were mentioning, and I don't know if that's like a number that you have, or was it an estimate of not the quota itself, but how many letters of support are being given to applicants?
I don't have that number, and I think that's an interesting question. There's no limitation on the number of letters of support that are being issued. And I think that's part of the challenge that IRCC has. They do have some requirements in terms of what designated entities have to do in terms of due diligence, but they don't have a system in place where the number of letters of support correspond in any meaningful way to the number of applications that they're processing. So if we take just the current backlog of about 15,000 applications, they're not going to even be processed over the next 3 years, right? So that's a mismatch that the government will have to eventually figure out, either increasing the number of applications that they're going to process, or making some changes in terms of how many letters of support can be issued. There's no solution on the table with respect to that yet, but I think that's an open conversation that we need to sort of check back in on, for sure.
Definitely. And a huge message here. Receiving a letter of support is not receiving your PR. So definitely another reason to think about that and prepare even better for the changes, even though some of them haven't been implemented yet. But we'll talk about that later.
For sure. Having mentioned what you just did, I think I'm just going to jump to point 3 here. One thing that the minister, now ex-minister of Immigration, mentioned at the conference was that they're going to try to prioritize certain applications. So within the 15,000 applications they currently have, there's going to be applications that are going in from, letters of support from different entities. And I found this the most open-ended and in a way troubling, because there's no guidance provided for this. But the idea that he put forward is that those that have venture capital support or angel support, angel investor support, or that they are part of incubators that are part of the Canada Tech Network might get prioritized processing. I have absolutely no idea how that would work. And why they came up with that. I think it is a way to sort of separate out the volume that they have to work through, but I don't see the rationale for it. I don't understand why particularly they chose this specific network. I've looked at the list that includes a broad range of incubators from across Canada, but I can't understand what the criteria is. Is it just people who, organizations that happen to have applied and been part of that network from before? It's not a qualitative assessment. So I'm watching this part very closely to see if they're going to provide clarification with this. And in fact, if they're actually going to go forward with this at all or not. I mean, it was an announcement, but there's no details of it. And it's been more than 2 months since that announcement and we haven't heard anything. So I think there's going to be a lot of pushback on that, because it's, it goes against those ideas of transparency and accountability in terms of how were these selected. And we don't want that, right? I mean, there's already questions about this program anyway. Making decisions like this in terms of prioritizing certain applications is going to cause even more friction down the line. So, but they might come up with other ways of essentially trying to limit applications in this way. As of this point, there's no clarification on that at all.
Yeah, I agree. It's a huge question mark. It goes a little bit against the designation of the organizations themselves and why would ones be prioritized ahead. Plus the fact that these are probably a very small percentage of the applications themselves. I mean, that's an assumption, but yeah, it's interesting to see what's going to happen once they make this official.
Yeah, I 100% agree on that. And then the one that I get the most questions about is the open work permits. This idea that applicants are going to get 3-year open work permits and that it will be for all team members. So right now, only essentials can apply for a closed permit. And this is the idea that everyone can apply for open work permits. I have different sort of feelings about this in terms of whether it's actually a good thing for everyone to be able to get open work permits. And I've been vocal on this before. And, Marianella, you mentioned that again, when people get that letter of support, it's the first step. If you think of it just as a work permit for coming to Canada, and, if it's a closed work permit, people are forced to work on their startup. But if it's an open work permit, things get a little bit tough. They start working somewhere else. And after 2-3 years, their resume looks like they're essentially, an employee of something else, and they've made tiny progress on their startup. It's sort of, I don't want to call it a trap. It's a double-edged sword. You have to be very careful in how, even if it does come to fruition, because we don't know, it was just announced and it wasn't something that was put forward with details. But if it is something that does come down the pipelines, and we do see this down the road, I think particularly for practitioners, if you're advising clients, you want to make sure that they really understand if you get an open work permit, great, you can work, but you really should remain focused on the startup if you want to apply for permanent residency through this program, because they will come back and they will check, and they do want updated Schedule A's, they want updated information about your startup. And if you're not able to demonstrate that, that's going to be a huge problem. So it sounds wonderful, but there are challenges. There's certainly challenges associated with it. So we'll see if it will even be implemented. But if it is, caution, word of caution.
Yes,
yeah.
Yes, definitely. This one, we were talking about this yesterday, Zeynab. For me, it's great news, but it depends on how you use it, right? Because it's the only one or a few of the changes that point like the other way around. They're like, make
Mhm.
sure this is serious, make sure your talent that is aligned to your startup, make sure you work on your startup. They're now
Mhm.
asking for updates about what you've been doing, because the time from letter of support and work permit to then PR is going to be extremely long. And then
Mhm.
now they're saying, okay, so please make sure that you're working on your startup. But hey, by the way, it's going to be now 3 years and you can work anywhere. So it's a
Yeah.
little bit confusing.
Yeah.
But I do agree. I mean, it's something that you can benefit from in like on one side, but on the other side, make sure that you know that this is not forever. And then after the 3 years, and when the time is up, you need to make sure that you are aligning the rest of your plan with the startup visa requirements,
Exactly.
right?
Exactly. That's right. That's right. Perfect. Um, I was just going to spend a couple of minutes talking about the trends. I call it trends and refusals, but there probably should have said trends and processing that could lead to refusal. So, um, you know, the additional instructions that were provided on the work permit side, I think are helpful as well for people who are putting together permanent residence applications, because you want to demonstrate from the beginning all of the eligibility criteria to the extent possible. So thinking beyond that checklist is important. Some of the refusals that we've seen, I want to just touch on them very briefly. Everyone has to now submit applications online, right? And where we used to have, you know, you submit your application within a month or so, you receive a file number. We now get file numbers a year, sometimes, you know, for older applications, much longer from the time of file submission. And what I have seen, unfortunately, is over the last several months, as applications have been opened by IRCC and they do their completeness check, they realize that there's a document missing, whether it's a language document or another document, or you know, the letter of support maybe was just beyond its validity, something like that. After a year, they could return the whole application to you and say this was incomplete. So lesson there. I mean, we've been able to deal with those depending on what the situation of the case is. But the lesson there is, and it does go beyond just startup, but with startup, the consequences are huge, right? Because your letter of support might have expired, your language exam documents might have expired by a year after, right? Other team members' applications are going to be in limbo if one co-founder's applications return. So the stakes are huge here. It requires much more diligent checking of applications before they're submitted to make sure all the forms are there, all the signatures are there, you know, that you follow the checklist requirements 100%. This takes a lot of time, but there's no way around it. And as I said, the consequences are pretty severe. So want to make sure that everyone's sort of just on top of that. Keep that in mind. The biggest challenge that applicants are facing now is we've seen a lot of activity from IRCC over the last year, essentially, where, you know, they're opening applications, they're processing them, they're asking for update requests, and they're starting to issue procedural fairness letters. So the update request typically will have minimum requirements. They will be asking for, you know, Schedule A's to be updated. So that's the activities that the applicants had. They will want updated police clearance reports. They will typically ask for medical examinations at that stage. And I think this is important. I think some people think, oh, I got a medical examination, the file is going to be approved or accepted. That's not the case. It's just one of the steps you have to go through. And then depending on who the officer is that's looking at the application, they're asking for documentation regarding the startup. So they could be asking for, I've seen all kinds of examples, details of the activities that you've done, details of activities you're going to do when you come to Canada, updated business plans, updated information about their progress, like documentation about their progress. So that's when they start to delve into, is this a genuine startup? And the way they're doing it is by going through and looking at whether there's been any progress. It is very tricky because the way that the program was initially set up, it did allow for people to say, when I come to Canada, I'm going to do these things, right? I'm going to incorporate, I'm going to implement the business. It wasn't envisioned that the applications were going to take 3+ years to process. And this is where the adjustment is coming in. And this has always been the case. If you apply for a work permit and you come to Canada, you definitely have to demonstrate progress. So for applicants who don't come to Canada and they're maybe working on their program, on their startup overseas and so on, I think that threshold of what you have to demonstrate is a little bit different. But 100% in cases that we've seen where people have obtained work permits have come to Canada, the threshold you have to meet of what you've been able to do and the progress that you made is quite high. And as a result of this kind of analysis that's taking place, we're seeing these procedural fairness letters where officers are essentially saying, we think these are artificial transactions, what you're demonstrating, and everything is for immigration purposes. And that's where it's extremely important for applicants and their counsel to make sure that they're putting everything in as a response to those procedural fairness letters. The better approach is to provide them at the update stage. Don't wait for a procedural fairness letter to be able to convince an officer. And certainly don't wait until that time to gather your documents, because they will be dated. If you get the procedural fairness letter today and the documentation you're providing is dated August, it's too late. What you want to do is collect and compile your documents and evidence as you participate in those various activities, so that when you get your update request, you can provide it. If you get a procedural fairness letter, you can provide evidence from 2021, 2022, 2023 that address all of those points. The challenge is I've seen people who have responded minimally to the procedural fairness letter and then been refused, and then come to me for judicial review and going to court. It is possible, but if the evidence that you had before the visa officer was not strong, then the chance of success in judicial review is going to be very low. So I say procedural fairness letters are lifelines. If you get, for whatever reason, you get to that point, it must be treated very, very seriously, with submissions that might even be way more detailed than the initial application that was ever submitted. And maybe the business plan needs to be updated. But in addition to that, oftentimes what needs to be done is demonstrating all those steps that were outlined in the business plan have been followed or progress has been made. Really, without that evidence, it's going to be impossible to get a positive outcome out of your application and also out of any kind of judicial review that we would want to do after. The final one, very quickly, is, time changes things. I have seen over the last 3 or 4 years, because of the delays, teams have changed the compositions. One of the essential team members no longer is able to immigrate. Those kinds of changes in circumstances can impact everybody else's application, so they can get very messy and very complicated. It is possible in some situations to be able to resolve them, but have to get ahead of them. And those are the kind of complex legal issues that I specialize in and I work on. But hopefully that doesn't happen to a lot of people. But as these timelines continue to increase, there are things to watch out for. And if you see that your, for example, team is changing in composition or people are changing plans before update requests are received and so on, you want to make sure you take proactive action on those.
Thank you. Thank you very much, Zeynab. And we have a few questions that are also aligned to some of the ones that we were wanting to, that we had prepared. So before we go to this slide, I wanted to ask regarding the minister's announcements, and it's a question from Sanjay Grover. And hi, Sanjay, very good partner of ours. He's saying these are just discussions after the minister's announcement, right? The ones that we were talking about in May, those are confirmed, but the ones after the announcement, there is no law on these as of now. He says, am I missing something?
He's absolutely right. The announcements that came in May are concrete. They're written. They're the policies that visa officers are implementing right now. The minister's announcement were just announcements. There's nothing that's been worked out in terms of details on those. That's right.
Okay, perfect. And I have a few others, Zeynep, but I'll let you go ahead on your other slides, and then we can
I'm
go through them.
just gonna wrap it up here. Really, I mean, I already talked about the numbers and the inventory. You know, processing times are increasing. The snapshot at the top is from May when I did another talk on startup visas. Processing was 35 months. As of now, it's 37 months, and it's likely that these are going to just continue to increase, which makes, you know, the point that we're trying to really emphasize here all the more important. Whether it's your own application or you're representing somebody, the commitment certificate is the first step, and all of the things that you have to do in those 37 months or more that it's going to take for that application to receive processing and hopefully be finalized and get a positive decision requires essentially implementation of that business plan and idea to the extent possible, and providing proof of that. So with that, I'm happy to answer more questions.
Wonderful. Zeynep, so we've seen the official updates, we've seen the announcements of updates that will come. What are your recommendations so that applicants can enhance their chances of success, considering these announcements and updates at the same time?
Yeah. The The program, as it was initially envisioned, has really changed. And while the government hasn't come out and specifically said that in their initial sort of, you know, what the PR program is, all the details we've talked about today point towards that. And I think whether you're starting your application new and sort of starting this process for yourself or for a client, or whether you're already down the path, you've submitted an application and you're waiting, this is the golden opportunity that you have, the time before your application is open for processing, going back to exactly the plan that you put together, and with your team, if it is a team or if it's one person, that one person, implementing it. This is like the only thing that I can say, because if there's going to be changes in the program, if there's going to be changes, for example, on the way files are prioritized, any of those things, what's going to be important is what you committed to at the beginning, what you said you were going to do. Have you been able to do it? And one of the interesting things, I think, in the startup world is that startups pivot, but that's not a problem, I think. I think as long as you can show what the process is, what progress you've made, how it is that you came to pivot, those will be acceptable. It's going to be the cases where, there's no progress, or it's minimal progress, where it's not going to be, it's going to minimize your chances of success.
Yeah. And like you said, Zeynab, it's not waiting for immigration to request these things that we believe they will eventually, or that they are already asking for. Try to make sure that it's a full file from the beginning, and that you save information so that when this happens, and if this happens, you are ready to deliver that information and not have to build it at that particular time, right?
Exactly. And I mean, usually update requests, you give you 30 days. Sometimes it's 10 days. So it really doesn't give you a lot of time to go back and have to reconstruct things. So it is a case of making sure you just have the systems in place to document the progress as you're going through.
Great. So let's dig into some of the questions that we have. A few very interesting ones. There are some that maybe are going to be specific, but I would encourage also if you could reach out to Zeynab. We've shared the information in the chat with her email. Okay, we have a question from Jamshid Dastur. Open work permit. Does this mean that the essential applicant is eligible to apply and work anywhere in Canada? And how much time and dedication needs to be provided to the startup until sustainability?
Okay. Anywhere in Canada, essentially outside of Quebec, because remember, this is the federal startup visa program, and one of the requirements is that you're going to settle outside of Quebec. So again, with the caveat that there actually is no open work permit yet. There might be an open work permit in the future, but if there is an open work permit, it will be anywhere outside of Quebec. The other part is, we kind of touched on this, I think, in our discussion. It's going to be context specific. I think part of the reason they chose to go with this, announce this idea of an open work permit is because other countries have it. So I think the UK system is sort of similar to this, where applicants can work at different places while they support their startup, but their program is completely different to ours. And the context of, if you are not able to show significant progress in your startup by that time that the update comes, and your main work has been somewhere else, then that's going to be problematic for sure. I mean, it is possible sometimes, we read about tech founders, particularly, who worked day jobs and then they worked evenings and weekends on their startup and were able to do a fantastic job and really scale. Mm-hmm. That might work for a small percentage of people. I'm not sure if it will work for a lot of people to have a full-time job in a new country, plus be able to build their startup. So it will be very case specific, but again, wait till we actually have an open work permit before we delve into this. Yeah.
We have a question from Ding Yang. So since the work permit is open, how can they prove that they work on their project? I mean, what tangible documents or evidence
it
can
would
be
be
shown?
the same thing. It would be the same thing that you have to demonstrate your progress now. Depending on what it is that your startup's going to do. If you said you're going to be registering patents, are you doing that? If you said you're building software, are you doing that? If you said you're going to have X number of customers, what efforts have you made towards securing that, right? So the evidence is not going to be different if you have an open work permit or not. It's just going to be, are you implementing the things that you said you were going to do as part of your initial plan?
I have a question from Elizabeth Roska. Will the approval of the PR application be dependent of the applicant coming to Canada on a work permit application and doing or starting the business first?
That's something that has actually been suggested to IRCC, that they should make this essentially kind of like the PMP programs that we have, where people come on a conditional sort of situation where they have a work permit, they meet conditions and they apply. That's not what the startup program is as of now. And the startup work permit is not a prerequisite to being able to apply to obtain permanent residency. Now, again, going back to the conversation we're having today, maybe in many circumstances, the progress that you could have made in your home country before coming to Canada is something that you needed 6 months, a year for. And previously, when applications were processed quickly, you didn't really need to be in Canada. But beyond that 6 months, 1 year, you might really need to be in Canada for the sales aspect of it, for certain meetings and like for really progressing the business. And in those situations, they might want you to demonstrate that you're making efforts. So this is a bit of a different question I'm going to pose. So we've had situations where people have been refused work permits, right? At least it demonstrates that they were trying to come, that they had made these efforts. There were various reasons that work permits can be refused, right? So I think it's not a requirement, but on a case-by-case basis, it's something that we can look at and say, does it make sense at this point, maybe a year, 2 years into processing, for the person to go back and apply for work permit to continue the progress of their startup?
Thank you, Zeynab. We have another question, Alex Goharju. After submitting the PR application, using the PR application portal, how long will it take to get the file number? How can we add updated or additional documents to the application when there is no file number assigned?
Okay. This is the beauty of IRCC. What can I say? With the pandemic, I think startup visas went down in priority. They were not opened. We submitted applications throughout 2020 we got file numbers in late 2021, early 2022. The most recent file numbers we're getting are about a year from the time of submission. So files that we submitted last summer, last fall, we're getting file numbers now. I still think that's outrageous. Like, there's no reason for it to take that long for us to just get a file number and that completeness check to be processed. It might go down in the coming months, I don't know, but currently it's about 12 months. You can, and this is an interesting question, this idea of should we be updating an application before we get a file number? And I would make that even broader. I mean, this is a question that we've discussed as well, that should you be submitting updates before the update request is really coming from an officer? I'm not sure that IRCC has the mechanisms for attaching documentation that you're submitting to the application. So I've seen this in various contexts. I also do a lot of litigation on refused applications, whether permanent residence, temporary, and so on. There's unfortunately, and it's kind of ironic, we're talking about the startup visa, but the technology that IRCC currently has, it's not guaranteed that you submit something, it's going to go and attach, and it's going to attach in the way that you want. I have been telling people that to collect the data, collect the documents, and so on, and we provide that at the update stage. There might be certain circumstances where after the file number, there's a need for updating certain information. So if there's changes in family composition or certain key information that has to be changed, so we would do that. But a lot of times now we're just waiting until the update request to submit things, because we find that things that were submitted earlier were just never seen or properly attached and reviewed correctly by the officers. But the problem is, if you try to submit anything before you have a file number, that's an abyss. I don't think they're able to attach those two files at all, even if you have a person's UCI number. And I've faced this challenge where a person wanted to withdraw an application that hadn't received the file number yet. And so that was the kind of challenge that makes me think it's extremely difficult to do anything before you have a file number.
Thank you, Zeynab. We have a question from Olena Korolova. It's specific, but perhaps we can have a broad overview. There are 3 essential members in a startup. All of them submitted their PR application 8 months ago. Recently, one of the members decided to leave a project and apply for PR using a different path. And you mentioned about these team changes, right? So she asks, is there any possible way to save the 2 other members from their PR being rejected?
It's extremely difficult. I've faced a couple of these in different stages, and the solutions will vary based on the team composition, whether that person was essential or not, whether they have their file number yet or not. I would encourage them to get in touch with me so we can speak on the specifics. I think it can be possible in certain circumstances if processing hasn't started yet and they're able to get an updated commitment certificate where they've convinced a designated entity that one person wasn't necessarily, like, they can continue to do the project and the startup without that person, even if they were initially identified as essential. But it's going to be challenging. I think the getting the commitment certificate requires a lot of work because of the due diligence part of it, but also then submitting it to IRCC and being able to convince them that the startup can continue without that person is going to be, it's going to be very fact specific, depends on the resumes of those people and so on. In some circumstances, they may just have to withdraw and regroup and maybe try a new application. So those are exactly the kinds of complicated situations where we need to sit down, go back and use our experience on different types of files to come up with a solution. Yeah.
Okay, Olena, you can reach out to Zeynab. now you know who to reach out to about this.
Yeah.
We have a question from Rajiv. How often are the audits taking place? Does the
I
audit
think
take
that
place?
means peer review. Is that probably what they're talking about? I don't have up-to-date information on the number of peer reviews taking place right now. We always, anytime we get statistics, are always several months or potentially a year or two gap between when they were generated and when we get them. I can't speak to that, unfortunately, in terms of how often they're happening, but there are situations where they're reaching out not just to applicants, but also reaching out to designated entities to be able to verify the due diligence that has taken place, or if people have said they've done certain things, verifying that that has actually occurred and so on. So they don't, the peer review is one of the tools that they have, but it's not the only tool in their box.
We have really good questions here on the Q&A. So I've asked Zeynab if she has 10 or 15 minutes more after. So we're going to stay. We understand if some people may have to jump off, you will receive the recording. So we're gonna stay here for about 10 or 15 more minutes. So we have a question from Mo Kohan. Should members receive salary from their own startup company while they are in Canada with a work permit status?
It's not a requirement. So this is essentially a entrepreneur closed work permit, the way it currently is. And the salary requirements as per IRCC's instructions have been zero. And that's important because I have seen, and we've had to deal with this for some of our clients, is that, remember, the work permits are issued under the IMP program. And IRCC conducts compliance reviews for IMP work permits in the same way as they do, as ESDC does for LMIA work permits. So we've seen situations where they've reached out to make sure that the various conditions set out in the offer of employment have been met. So there's no requirement to put a salary in there. It could be zero. Now, I think that gives people a lot of leeway. If people make the mistake, if an applicant makes the mistakes and writes a salary in there, let's say 100,000, I'm just picking a number, and then they come and for various reasons they don't pay that salary, they could be found non-compliant because they should have, right? But if you put zero, which is what the guidelines provide for, and then the business does well and you do receive a salary, then that's fantastic. It's great. It's also, I think, proof that your business is doing well and that it's able to support you and so on. But there's no requirement that there has to be a salary payment for you as a co-founder. No, that's why you have to show the 1 year of savings, right, when you're applying for the work permit.
Correct. Great. We have a question from Harmanjot Sodi. The commitment certificate is valid for only 6 months, and if the PR process takes 3 years, then do we have to keep giving commitment letters every 6 months?
No, you would need to. So if an applicant submits their application while the initial commitment certificate was valid, then they're done. They want to apply for a work permit and the commitment certificate is no longer valid, yes, they'll have to get a new one. Now, the interesting question, and we don't know this, we'll have to check back in about 4 months or so, is if you, actually no, in about 8 months, if you applied under the new rules, so the May 2023 rules that say you need a current work permit, current certificate at the time you submit your work permit, and somebody had an approval, let's say in June or July, and it's coming up to a year, because typically these work permits are issued for 1 year. So it's coming up to a year and you're renewing it. Do you need an updated commitment certificate? I think that's an open question. I'm not sure you do. If you do and the officer asks for it, then that's, I think, a time where you will need a new commitment certificate from the designated entity. But I think that's still an open question. I'm not sure if that's the case. Honestly, I think what would have been a better move for IRCC is, instead of creating 3-year open work permits, was to have a clear 3-year or 2-year closed work permit and have better processing of those applications. But my 2 cents.
I think this webinar has to be continued at the end, right?
For sure. We'll
sure.
have to come back.
Exactly. Question from Jay Lee. Is it still valid that there is no relationship between PR and the success of the startup visa venture? Simply, your business does not have to be successful in order to get your PR.
Yes, I think there is a simple answer to that, because the permanent residency is not tied to business success. Now, there's 2 aspects to that. There's the idea of, if your business completely fails before you get permanent residency and you say, I've just given up, then I think that is different to a situation where after you get permanent residency, you've tried and you've done various things, you've pivoted, and the business is not successful. Are they going to take your permanent residency away from you? The answer there is a clear no, because it's not a conditional permanent residency that you're obtaining. But that first part is more complicated because, again, while the processing was very quick in the past, and it was unlikely that a business was going to fully fail before the application process was completed, now it might happen that could be a scenario. And I think what's going to be really important is what people can demonstrate in terms of the efforts they made to build the startup, support it, grow it, pivot it if necessary. But it's not, after you get PR, it's not tied to business success. No.
There's a question here from Ying Zhu, and I also have this question because 3 years is a very long time. So Ying Zhu asked, will they be able to apply under other immigration programs, for example, CEC, if they've gained eligible work experience with a potential open work permit or their spouse? This goes back in 3 years, to, right?
You're absolutely right. This is where, going back to that idea of the circumstances and team compositions can change. I've actually seen this where the founder's spouse was able to obtain sufficient work experience that they qualified under CEC. And because the processing was faster, they switched. Now, in that case, thankfully, there was no co-founder. So that was a situation where they could just withdraw and do that. There's no prohibition. The challenges are, if you have come under a closed work permit for your startup, your work experience in Canada is going to be considered self-employed, and so it doesn't count for CEC. But as you said, work experience of spouses can count for points. It gets complicated again if you have co-founders and you have one person who goes off and makes a different kind of application. And then, the other co-founders because they were essential and they got the work permit, the other co-founders are going to, unfortunately, probably be refused, right? Unless there's a very small window that they make any kind of change in their application. So there's no prohibition preventing that. And it might be a strategy for some people who have that option and hopefully don't have co-founders.
Yeah, that's a tough one. We're trying to encourage startups, not break them before they start, right?
That's right.
Great. Let me see. I have a few other questions. If a PR application is returned as incomplete, does that mean that the 37 months for all founders starts from zero again? Or will the reapplication be processed aligned with the other co-founders' PR files?
That's a very good question. The couple of situations where I've dealt with, we were able to get the file reopened as opposed to doing a new application. Okay. Because a new application would go at the back of the line. A reopening would allow you to essentially get them to reverse the decision on the completeness assessment, right? And that shouldn't impact their place in the queue, so they remain where they are. But that is a problem that, again, because IRCCs, I think this is to be applauded. They did a fantastic job of trying to do everything very quickly during the pandemic to move things online. But it is challenging, and their systems are just not able to, for example, as I said, attach documents to applications very well, or they can't be responsive on things that are not assigned a file number yet. So if you have a situation like that, and the other part is, unfortunately, there's not a lot of human beings that you can reach out to. There's only forms and stuff that you can send. So if you have a problem like that, it becomes very tricky. We've even had to resort to judicial review, filing a judicial review to try and resolve that kind of situation that comes up, and we were able to get a resolution on it. But it could happen that the person might end up being at the back of the line, and that could delay everyone's applications. Yeah.
Thank you, Zeynab. We have a question from Quang Vo. Does the fact that an essential member applied for work permit but later stayed in Canada for a very limited period of time have negative impact on the PR approval?
We haven't really talked on this. I think it was, a 1 hour session, and we already know we're going to have to do another one. So I think maybe next time we'll talk about the case law that there is for the startup visa applications. There's been some interesting cases that have gone to the court. And I want to just maybe touch on 2 quick points here. One, with respect to work permits specifically, I think the answer to that is it does impact processing. I mentioned earlier, if you get a work permit, the expectation that the officer is going to have in terms of how much progress you've made is going to be higher. So if a person obtains a work permit, comes to Canada maybe for a month or 2, and cannot demonstrate significant sort of progress with regards to their startup, I think there's a much higher chance that they will be refused. And not just that when they are refused, the court is not going to be willing to sort of step in and accept that, they were going to do things after they came because they already got the work permit. Now, if there might be a situation where someone gets a work permit, they come, but the way that the startup is structured, they need to travel back and forth, or there's significant work being done on, for example, software development or other kind of development that's taking place outside of Canada, and they can demonstrate that. That could be a situation where they might be able to overcome that challenge. And that would be probably, a situation where they're going to get a procedural fairness letter, and it's going to be critical to make sure that that procedural fairness letter response that goes in highlights all of those and points to the law as well as the evidence that's in there. The second point I'll just mention is with respect to judicial review and dealing with refusals. We work in the space. I do a lot of consulting work on this. I mean, I don't work on the part of getting letters of support. I think that's a very complicated and specialized area. But anything that is from the point where people get their letter of support and beyond in terms of refusals, and we understand the program. We know what the requirements are. We know what the history of the program is. That's not necessarily going to be the case. It's not going to be the case when an application is refused and they try to do a judicial review. I've sat in on hearings where the judges that were deciding on judicial review of refused startup visa applications had no idea how the program works, what a designated entity is, what the purpose of this program is, what needs to be demonstrated, what the legal basis is. And so it's extremely challenging to do that. And, there are lawyers that do a lot of judicial review, but there aren't many that do specifically within this space. And I think taking the experience of someone such as myself, explaining that you need to make sure you have those documents on file from day one, that you submit the PR, collect everything, respond to procedural fairness letters with great detail and documentation, so that if, unfortunately there is a refusal and you do contact someone like me and we are going to do judicial review, we have the evidence. And then, also the know-how of how to educate the court in terms of what this program is and how this person really did qualify and provided this evidence, and this is really a mistake. Otherwise, there aren't going to be a lot of options if that person is refused and they didn't provide the evidence of for example, they came to Canada, but the work they had to do was back in Nigeria, and they had to go and they had to manage the team that was doing the programming, right? That's a critical piece of information. If the documents and evidence of that is not on file, when that file is potentially refused, there's not a lot that can be done.
Thank you, Zeynab. This question, I believe you've touched on it already, but I'm gonna highlight it. It's Hesam Nafari. Hi, Hesam. During the time which the file was submitted, if the team doesn't have any activity, what will happen?
You mean by the time that they reach their update stage? I'm assuming that's what the question is.
Exactly.
If they get to the update stage and they've done nothing, and it's been like 3 years, I anticipate that they're going to receive a procedural fairness letter. And that procedural fairness letter is going to say, I believe you're made this application simply to obtain permanent residency. Now, they might be able to try and go and say, well, we were waiting to come to Canada to implement our plan. But I think, again, passing of 3 years, maybe more if it's going longer, is going to make it very difficult for an officer to accept that, right?
Yeah, makes sense.
And I think the chances of success for those applicants are very low compared to, again, 2018, 2017. They weren't even asking for that because the processing was much, much faster.
Exactly. Thank you, Zeynab. So thank you for 127 people are still logged in. So definitely people are very interested in this topic. So I want to thank everybody for staying. I know there are many more questions about this program, the updates, what may happen, and the opinions of Zeynab on this. Zeynab, I couldn't imagine having anybody else better than you as a guest for this topic. So I want to let you know how much we truly appreciate you being here.
Thank you very much. It's been a pleasure to talk about this. I'm a bit of a nerd on it, so if I go into a lot of detail, it's because that's what I do every day.
I love that. I love that, Zeynab. On our side, for those who haven't worked with us at Joorney, we're preparing business plans and pitch decks for the start of visa at the letter of support stage. Even though that's just the beginning, we are supporting people to prepare their documentation and make sure the designated organizations have what they need in order to make their decisions. And we've not only done business plans and pitch deck, but we have packages that are tailored for designated organizations. And then at the update stage that Zeynab has been mentioning, we are getting also requests. Some of them we do as courtesy, some of them depending on the time that has passed from the original business plan. Of course, we may have to have additional charges, but we're here to support them, to update the industry and market analysis, to update the timelines and the things that have happened. And we're making sure that all of these announcements and changes, things about significant benefit, about the background of the applicants, are definitely being added to the business plan so that they are comprehensive, robust, and very aligned to what immigration is looking for. So thank you, everybody, for being here. I really appreciate it. Till next time. Bye, Zeynab.
Thank you. Bye-bye.
Thank
Bye.
you.